Welcome, everybody. I hope everybody's doing all right today, staying safe. To get started, one of the features here with the Zoom webinar is that we're able to share, I'm able to share my screen with you guys, but you all appear on either the right-hand corner at the top, so you see everybody's name popped up. To be able to view the presentation a little bit better, you'll see that above where the pictures of the different participants are, you can hit the little symbol as shown by the picture on the screen, and it will minimize that so that you only see me, and that way you get to see more of the screen and more of the material you're looking to get at. Does everybody see that?
Yes.
Okay, very good. All right then, well, let's get started. Well, thank you for joining today. So the subject of our conversation today is going to be about protecting your children, even when you're not there to protect them yourself. And so let's talk first about modern parenthood. These are different times than what our parents grew up in, and frankly, our circumstances are different. I say we because I consider myself younger and I've got a family of my own. So this is all very close to heart to me. And, there's different concerns that we have to deal with. And our lives are different, different stages of life. For example, young people have the feeling that they're always rushed, and it's true. I am constantly feeling like I'm rushed. I talk to my wife and she's definitely always feeling rushed. So there's this, you'll see the chart here. And what that is it's built off of a Pew survey that was done a couple of years ago. And it breaks down how dual income couples divide their time. And as you'll see, some typically in marriages, one participant will more likely work than the other, but then the other will take more of a burden on the housework and childcare. And when you actually combine everything together, the wife actually does more work, at least on average. I know that a lot of people would argue with that. A lot of wives would say, oh, it's more than that. But the point is, as young people, it's just our lifestyle. We're busy really developing our lives. We've got young children who require a lot of attention, and we're just really got a lot of issues going on that we're trying to tackle at one time. And so really what we've done is specialize this seminar and this webinar to meet the needs of younger clients. So typically our clients are above the age of 55. And one of the main reasons for that is, first of all, they're typically more motivated to get their estate planning done because, well, honestly, there's a more imminent fear of death or disability. However, it's also just very difficult to get young people to take action with their estate planning, even when they know that they need it. And we'll get to some of the reasons why that is. But for our normal seminar, what we try to address are the 6 major concerns that we see from and hear from our clients. And again, those are typically older clients. So the first of the major concerns is they want to eliminate government involvement after their passing. They don't want the government getting their hands into their personal business. Makes perfect sense. Next is that they don't want to pay any extra taxes or fees than they already have to. A major concern also is to avoid nursing home costs. Nursing home costs can just destroy an estate near the end of life. Next, they want to protect their children and their surviving spouse from creditors and predators. And then they want their death or disability to be a time when their family is really brought together instead of torn apart. And then lastly, they want to be able to share their stories, their wisdom, really the legacy of who they were more than just a name on a family tree. They want to be able to pass down how they were good stewards of their family and of the legacy of the family. But these may be some of your concerns. In fact, they might all be your concerns. But like I said, this is not your parents' estate planning workshop. This is specifically designed for younger couples. So let's talk about why we're here. For myself, I'm passionate about this stuff, and I can relate. I have an 8-year-old boy. He's about to turn 9. I've got a young family, and I know the concerns, and I know how busy life can get. And another thing is that it worries me how many people out there that I know that don't have estate planning. A lot of my friends are about my age, and they have young families as well. And it's something that is constantly on my mind when I'm with friends, with family, knowing that, well, they just had a kid. I wonder if they're protected or not. And a lot of times that they aren't. In fact, there was a study done several years ago by caring.com. And what it showed was that really only 4 out of 10 Americans have estate planning documents put in place. I mean, every 6 out of 10 have nothing in place. That's a big deal. And as you get into older age groups, the percentage of people who do have planning increases. Like I said, most of our clients are 55 and older. So that means that of the younger generations, there's a huge number who are unprotected, who don't have any planning put in place. I mean, the numbers are in the 80 percentile. And so you might ask yourself, well, or I'm going to ask, why are you here? What about you? What caused you to watch this webinar? And one of the first examples of why younger people might consider doing their estate planning or really become motivated on taking action with their estate planning is that they've experienced a life-changing event. So have you had children born recently, perhaps a marriage or a divorce? Did you get a promotion? You know, there's something in life that caused you to take action. And so that's pretty typical. Now, another reason why you might be here is that you've suddenly had a realization that circumstances can change quickly. So I'm not here to be a fearmonger over the COVID-19 virus. I'm not saying that you're in any additional need for estate planning because of it. But what I do want to emphasize is that it's the perfect example of how things can go downhill quickly. I mean, just at the beginning of the year, nobody was thinking about this thing. And now our society is basically paralyzed because of it. So things can change quickly. And a lot of younger couples just don't really have that sense of urgency because they always think, well, there's always tomorrow. And then I'm gonna, real quick, I think somebody's not on mute. There we go. Okay, and then lastly, something that can bring young people into the realization that they really need to get something done is that they've had an event that caused them to be reminded of their own mortality. I mean, I hate being reminded of my own mortality, but it happens. Either a close brush with death on the road, or perhaps something happened to you medically, it being, let's say, appendicitis or something like that. Something where you realize, holy cow, that was close. Maybe I should get something put in place. Well, that's a good reason to get something put in place, but guess what? It's a good idea to have something put in place either way, just in case anything like that happens. And so some of you watching may be first timers. You may have never really thought of this before. Others of you may have been meaning to get this done, but have just been putting it off because, well, hey, there's always tomorrow, right? Well, not always. Either way, everyone is welcome. Everybody who's watching this is going to benefit from it. And I'm really glad that you're all here. Like I said, it's hard to get younger people motivated to get their estate planning done. So let's take a look at that. Now, this was done a couple of years ago. There was a survey done by dailyfinance.com. And what they showed was that of people under the age of 35, I myself am turning 34 in just a couple of weeks, more people were worried about fluctuations in their weight than they were about their estate planning. I mean, does that sound familiar? I know that I could relate sometimes. Mainly, I know I've got my planning set up, but people are always worried about their weight, and it's so fickle. But it's not nearly as important as your estate planning. Now, here's one even further, and I was surprised by this. The same survey also said that 32% of people 35 and under would rather get a root canal, work on their taxes, or even give up sex for a month rather than do their estate planning. Give up sex for a month? Really? It's not that bad, trust me. And it's important, it has to be done. So I know all those things sound terrible, and they are terrible. Estate planning is not that bad. In fact, you'll feel much better after having gotten it done. In fact, that's what we provide, is that peace of mind. You're gonna feel a lot better once you get something put in place. Okay, so what do we typically hear from younger couples? Well, first of all, you've got those out there that say YOLO, you only live once. So I'm gonna spend every dollar I have, and everything else will fall in place, and I'm just not gonna worry about it. Well, that's definitely a bad idea. And my guess is that if you're watching a seminar or a webinar on estate planning, you don't fall into that group. So what do we hear from the rest of the people? Well, it's either I'm not there yet, meaning I haven't reached that financial plateau or summit to where I'm in need of estate planning. A lot of people think of estate planning as only being needed for old rich people, and that's just absolutely not the case. In fact, your finances are not the first thing we're worried about. We're worried about your personal circumstances. Another common thing that we hear from younger couples is, well, I've got time. I'm not gonna rush to get something done, or I'm not gonna really worry about this too much today. I can do it tomorrow. I think we all know that tomorrow is never a guarantee. And like I touched on earlier with the COVID scare that's going on right now, it's just a realization that things can change more quickly than what we anticipate. In fact, I recently likened it to when I was a kid. I used to think, I don't need to wear my seatbelt because I'm going to see the crash coming and buckle up just before the impact. I mean, now I know that's just ridiculous. And the same is true with estate planning. You should have this stuff in place in advance. Buckle up when you get in the car. Have your estate planning done before something happens. And then the last one is, well, my wife or my husband is going to take over anyway. They're going to handle these things. And for that reason, I'm just not going to bother with it. Let me tell you, there's a lot of reasons why that is wrong. And your spouse is going to have a headache having to deal with taking care of your estate. Your estate planning is not about you necessarily. It's really about your family. It's about making their job easier. Sure, your spouse will handle it, but are you going to make it harder on them than it already has to be, especially when they're grieving over your death? It's just not a prudent idea to think that way. All right, so let's take a look at those arguments and really see where estate planning falls on the spectrum of importance. So how many of you out there on the webinar have had their house ever burned down? I can't see your hands, of course, but I'm guessing it's none of you. It rarely ever happens, right? However, how much do you pay for that insurance every year, every month? I mean, it's hundreds or thousands of dollars for something that's a low risk probability. But you want to have that protection, of course. We all do. So let's compare it. What risks do your children have if you don't have a plan in place? What is your true legacy? So if you don't have a plan in place, it's not just an asset that's going to burn down. It's going to affect your children most likely for the rest of their lives. And really, you got to think about what is most important to you. For me, it is my son and my wife and my family, and really the legacy that I'm going to leave behind, because our children are our legacies. They will live on, hopefully beyond us, and carry our stories, carry our values into the future. And really, that is what is so important. So it's absolutely important to get protections in place for those kids. So what we're going to do today is we're going to show you how to protect your children, and even if you are not around to do it yourself. And so we're going to work on giving you the information that's needed to know how to protect yourself. And then what we're going to try to do is get you to take action and act on that knowledge. All right, so you might wonder, why am I listening to this guy named Chris Brown on a Zoom webinar, talking to me about all of these issues that are so important to my life? Well, it's because not only do I have the education and the professional experience to handle these issues, I've also got a close personal experience with estate planning that I've lived with my entire life. And I've also got just a true passion for these things. And so it's something that I hold dear to heart and really want to share with the world. And so I was actually raised by my grandparents, and this goes a little bit to the understanding of what a modern family is. It's complicated. And so I was raised by my grandparents because my parents got a divorce at a very young age, and they were very young themselves. And so I was raised here in the Houston area. I went to Cypress Springs High School. When I was there, my sophomore year of high school, I met a beautiful young lady, and I put my arms around her and really never let go since. And so I am married to my high school sweetheart. We've been together for nearly 20 years now. It's maybe a little bit less, 18 years. So really just truly blessed for that. And after high school, my wife and I both moved up to the North Texas area to go to university. I graduated from Texas Christian University in 2009 with a double major in finance and supply chain management. Now, you might remember 2009 was a terrible time to be graduating with a finance degree. So I ended up working in a supply chain management role, which was fantastic. I loved it. I was working on production control for the F-16 fighter jet program at Lockheed Martin, and really cool stuff. I was working half my time on the shop floor with shop mechanics and sitting inside fighter jets, and I loved it. And the rest of the time was working on logistics and coordination issues. And I learned a whole lot, first about airplanes, of course, but my time there was really learning about people. I had to learn really how to deal with all sorts of people, and mainly understand that listening is what is most important. And that's something that I really try to carry forward into my role today, is active listening skills. While I was at Lockheed, my wife gave birth to my one and only son. He's now 9. And so when he was, the day he turned 1 year old, actually, we moved from Fort Worth and moved back down to Houston because we wanted to get him closer to the rest of my family. And I wanted to push myself further by going to law school. And so I went to the University of Houston Law School and graduated in 2015. Right about that time, I started working managing assets for a large family limited partnership. It's really an estate planning mechanism. And then after becoming a licensed attorney, soon after I began working at the bond law firm, and just recently have been made a partner. And so you may have noticed on the introductory screen that we are now officially the Bond and Brown law firm. And so I'm very excited about that, and just incredibly grateful to be working with somebody like Mr. Bond and the entire team. Everybody is so passionate about what we do here. But really the most important reason why I do what I do is these people right here, my wife and my son. I am a family man through and through. It's really is what's most important to me. It's what makes me happy. And it's what I care about most are those people that you see right now. Okay. Obviously, these things that we're talking about are important. So why don't people take care of these matters? I mean, it's so important. Well, the first reason is the most obvious: procrastination. See, estate planning is something that is easy to procrastinate on. And the reason for that is that, yes, it's extremely important. And I think we can all acknowledge that. But it's also not perceived as being urgent. And so there's always this perception of, well, I can do it tomorrow. I can do it tomorrow. I can do it tomorrow. Until eventually there is no tomorrow, and it never happens. And so it's like there's this procrastination monster, and it just grabs it and won't let go. And so what you have to do is just absolutely take action. Now, additionally, the second reason why a lot of people don't take action is because of a lack of knowledge. So a good example is, let's say you're buying a house or a car. What's the first thing you do? You go online, let's say it's a car. You go online and you look at all the different models out there, their gas mileage, their dimensions, their horsepower. You learn everything you can, right? And then you look for the best deal. All of that takes time and effort. Well, the same, if not more so, is true with estate planning. There's so much information out there. And quite frankly, there's so much out there that there is a need for estate planning attorneys. We have a very real need out there in society. And so a lot of people end up thinking, I'm going to do it myself. I'm going to learn what I need to know. I'm going to download some free forms online, even though I really don't know what the legal impacts of them are. And people end up getting online, they do some research, and then they start running into, oh man, do I do this or do I do that? Well, what if this factor is at play? It gets complicated, I promise you. And so you end up hitting a roadblock and the whole thing just drops off a cliff, never gets done again. And so my goal here today really is to provide you with the information that you're going to need to be able to address these issues and feel confident talking about what your risks to your family and to you are. But then additionally, it's going to be hopefully a call of action to take action. And to that point, you got to ask yourself, with the knowledge that I'm going to gain today, is knowing enough? Short answer is no, it's not enough. So we're going to provide you with the knowledge, but our real focus is getting into action. And a good example of that is, well, I'm sure pretty much everybody online here now has at some point or another tried to lose a few pounds, right? I'm doing it right now. So what do? You know, you got to eat better, eat less, eat healthy, and you got to work out. You got to get more active and burn calories. But how much weight has anybody in the history of the world ever lost from just knowing those two things? None. You don't see any results until you take action, until you make a commitment to yourself, maybe to others, that you're going to do something to change your circumstances. And the same is true with estate planning. What we're going to try to do today is get you to take action and stop procrastinating, and really just allow yourself to have a peace of mind moving forward. Okay, so some of the things that we intend to cover today are, first of all, we're going to talk about estate planning for a new generation. So this is different than perhaps what your parents have set up, different needs, different circumstances. We're going to especially talk about protecting your children if you're not around, and what the impact of a serious accident or illness would be. And we're also going to talk about what the impact of your death would be upon your family. And then we're going to talk about how to pick a guardian. You might notice the picture above there is a unicorn. I thought that was pretty funny, but also pretty accurate. Picking the perfect guardian is difficult. It's like finding a unicorn. There's so many factors at play. So we're going to talk about that in detail. In fact, in our consultations for will packages, talking about guardianship and figuring out who's going to serve as guardian is typically the client's hardest thing to decide upon. Additionally, we're going to talk about how to secure your child's financial future. We're going to talk about personalized solutions just for you and how we come to that conclusion. And then at the end, we're going to have time to answer questions and have a Q&A session. So here's a question for everyone. And I know it's a little dire, but what would happen to your children if something catastrophic happened to you? It's a terrifying thought, right? Well, a lot of people asked, what's my biggest fear for my children? It's their response isn't that their biggest fear is my death. It's, that my child gets a disease or maybe has a drug addiction or something like that. But what's really impactful is if something happens to you, that is going to have a huge impact on your child's life. So what would happen? Do you have any idea? Let's say you do have some idea, or at least you think you do. Are you confident in it? Or are you like most people who think they have some idea about their estate planning? It's typically based off of some loose promises, some rough ideas of how things work, and a good bit of wishful thinking. The point is, things can happen. And in this seminar, I'm going to talk about some stuff that may scare you. It's not intended to be a scare tactic or anything like that. What I just want to do is express to you some of the risks that you face. That way you can take the appropriate action to remedy and mitigate those risks. All right, so let's talk about a fact pattern that, well, most of young parents would be able to relate to. Oh, that special date night. You have finally gotten time set aside out of your busy schedules to where you and your spouse get to go out on a date. Well, right now with the stay-at-home order, I am pretty sure everybody is itching to get out on a date, but young parents especially, with young children in the house. I know I'm looking forward to taking my wife out once all of this is over. So what do? You call a babysitter, right? That's the first step to securing a babysitter. And then you make reservations at the restaurant, maybe buy some movie tickets online. So it's gonna be a great night, right? So when the babysitter shows up, what do typically mothers end up doing? Well, they leave a list of things and instructions for the babysitter. Brush, make sure the kids' teeth are brushed. They have to go to bed at 8 o'clock. Certain snacks they can and cannot eat. Just anything that is small that you can think of that in the next couple of hours, whoever's watching your kids might need to know. However, these are really just small facts. I mean, you may be thinking, what could go wrong? Well, we'll get to that. So on this date night, again, this is a worst case scenario, but these things do happen, is that it was a rainy night. And typically in a law school, most bad situations started off with, it was a dark, rainy night. So it was a dark, rainy night, and there was a drunk driver, and he runs a red light. You know the story from here. There was an accident, and now what is going to happen? So there's two different scenarios that we're going to look at that are possibilities of what would happen after the car crash. The first is that you're seriously injured and will be in the hospital for an unknown amount of time. The second is that it's a fatal crash and that you will not be coming home. Both are terrible circumstances and both need to be handled a little bit differently, but both need to be prepared for. So let's say first that we'll look at the first scenario, is that the crash was not fatal, but it was serious. And now you and your spouse have both been rushed to the hospital and are both unconscious. So what is it going to look like? I mean, you can just see this out in your head. First of all, the babysitter is going to be frantic. She's going to say, they should have been home hours ago. What should I do? They're really freaking out. So hopefully you left some emergency contacts for them, but either way, eventually the authorities will arrive at the door, and once minor children are discovered, then they'll be forced to investigate further and step in and take care of the issue at hand, which is that there's children without guardians in the home, and somebody needs to be taking care of them. Now, you may have already said to yourself, and we also understand that you may have already have friends and family members that are ready to step in. You know, I've already talked to my folks, and they've said that if something happened to me, they agree to watch my son until he turns 18. You know, it's a huge favor they're doing, and we've already had that conversation. Well, guess what? The legal system does not work on casual promises. I know that that's who you want to be your guardian, and they want to be the guardian, but there are huge logistical issues to face in between. And that's why it's essential to have signed legal documents in place to address these sorts of scenarios. And the government will get involved. The fewer documents and instructions that you have in place in legal signed documents, the more the government will be involved. And so Child Protective Services are typically notified in a scenario like this. And they'll get the message that minor children are alone without authorized legal guardians. And so what will need to happen is that an emergency guardianship will need to be established. But what happens in the meantime? Let's say it is your parents, but they are maybe across the country, or they're just not available right now, or whoever it is that's going to step in. There still has to be a logistical period where the government is keeping an eye on things to make sure that your children are going to be getting the best care that they can. And during that period, they're likely going to be watched over, either supervised or checked in upon by Child Protective Services to make sure everything's going okay. And without some legal directive or instructions, the court is going to have to step in. And that's a good thing. You want that. I mean, these are your children we're talking about. You want the court to make sure that their best interests are being looked after. You want them to be overly protective when it comes to appointing a guardian. But the court is going to have to take into consideration all potential guardians that might be out there. And you're really leaving it up to the court if you don't have the correct documents put in place in advance. Okay, so typically next is that the family or your children are ultimately released to the family member that is going to be their guardian or emergency guardian once the court has approved it. And so the family is reunited. But I want to plant this seed in your mind, because we'll talk about it in just a little bit, but the court has appointed a suitable guardian. Well, to you, what exactly does a suitable guardian mean? Because it is a bit of a loaded question, because there are so many factors at play, just like I mentioned earlier. And so we'll talk about some of those factors in just a bit. So you really have two methods for appointing an emergency guardianship, or there are two methods that emergency guardianship can be appointed. The first method is that there's a signed directive by the parents. Now, this is obviously the best method of having a guardian appointed, because first of all, you're the one who is choosing who the guardians should be. Additionally, you're leaving out a lot of the uncertainty, less court involvement, less, let's say, interjection from the courts. Now, secondly, is your other option is a court-approved order. Now, that's basically saying there was no document, so we, the court, are going to appoint somebody. First of all, this is going to be difficult, more difficult than if you had documents, by a long shot. Also, it's going to be more expensive. The more difficult something is in court, the more something has to be carried out in court. It's going to take longer, and it's going to be more expensive. That's true anytime you got to go to court. All right, well, now moving on to the next scenario. We just talked about what if you were disabled and we're in the hospital, perhaps in a coma. What if in the scenario, after the car crash, you're not coming back home because it was a fatal crash, and now your children don't have their parents? It's a terrifying thought. So what we need to have happen now for the children is that there be a long-term permanent guardianship established. And so this can be a rigorous, complex, and lengthy process. And like I said before, anytime something is lengthy and complex in court, it's going to be costly as well. And really the concern isn't just the finances, of course. It's the impact on the children's lives. And so there's the potential that without the proper documents in place, your kids are really going to be the rope in a tug-of-war battle. And because the court is going to need to consider all eligible candidates that can be considered as a guardian. Now, a lot of times that's the in-laws. So the wife's parents and the husband's parents both think that they are best suited to fill that role. And also, you know, it's each one of them look at it as want to lose being able to spend their life with their grandkids. And there's a fear that if the grandkids to the other spouses, there's a fear that if the children go to the other spouse's parents, that, well, your parents just aren't going to be as involved. And so there's a big fear about that. And there can be a battle. And children end up getting caught in the middle, and families get torn apart. I can talk to that personally because I mentioned at the beginning that my parents got divorced when I was at a very young age. Now, this is a different fact pattern, but from the standpoint of the children being caught in the middle of a tug of war, this is the same. It was an ugly divorce proceeding between my grandparents and my mom. And I remember, even though I was 3 years old at that time, I still remember the way in which I was manipulated for information, that both parties were pitted against each other, that each party would, well, especially one on my mom's side, really pit me against the other party. And there's a lot of impacts that can happen to that person as they develop. And so you really do want to avoid that happening to your own children, because you're not going to be there to protect them. So we've really painted an awful picture right now. And like I said, I'm not evoke fear. I need you to be aware of the risks that you face. And you've got to be out. But is there a solution picture? There is. Of course there is. And we're going to talk about that. So the parental nomination of emergency guardians, that's the first thing that you can do. is have a legal directive put in place that says who you want the guardians to be. It's not a complicated form, and we'll talk about it, and it's included in our plan, but it needs to be there. But then you got to ask yourself, okay, what makes a good guardian? Because like I said, it is always a difficult choice. Many people want to look and see, okay, well, I'm just going to pick somebody who's wealthy to be the guardian of my children because their wealth will help make my child's life easier. Well, that is really the wrong way of going about looking at this. Wealth, yes, it is an important factor, and because you want to make sure that your children are taken care of financially, but there's so much more to it, and so we'll talk about that. So what makes a good guardian? These are just a couple of the factors to consider. But first, you have your parenting philosophies. Really, how are they with kids? How do they behave with their own kids? Their religious beliefs. Do they share the same beliefs as you? Their geographical location. Are they near the rest of your family? Is your child going to be uprooted and need to move across country? Of course, discipline styles. Are you more of a, or less of a capital punishment person, but the person who you're thinking of being the guardian is more of a capital punishment kind of person, you know, a good backhand every once in a while? It doesn't agree with everybody. So people have different discipline styles, and you want to make sure that your guardian has the same style that you approve of. And then there's personal values. This is really, I think, the biggest one. And it's, each of us have our own set of personal beliefs, and really how I would define integrity as being how closely we adhere to those personal beliefs. So does the person have integrity? Are the personal beliefs that they share, the personal values that they share, the same as your personal values? And do you think they are the kind of values that you want your children to have when they get older? And then, of course, you've got personality types. You know, are they a jokester? Are they very serious? There's all sorts of different personality types. So again, it's most likely your child is going to, in some way or another, mimic the behavior of their guardian as they develop and get older. And so what kind of characteristics in their personality do you want to see develop? And then lastly, temperament. Even nice people sometimes have a very short fuse. So it's good to have an idea as to really how does the person look at the world? Are they always a victim, or is it a pick myself up on my bootstraps kind of person that's going to overcome adversity? There's, again, so many factors to consider, but all of them are very important. Another thing to consider is, are they parent material? So one big thing is, it's important to, you might know a great guardian. They're rich, they've got great personal values, live in a great school district, you know, just perfectly fit the bill. But here's the deal. They are friends from college, live halfway across the country, and have never met your child. They may not actually be a good fit, because it's important that your child have some familiarity with the person who is going to be their guardian. I mean, they are already going through probably the biggest life change that they'll ever go through, honestly. And so some familiarity, some consistency in their life, being with somebody who they're already familiar with, is an extremely important factor to consider. Some other items are that you can ask yourself, and all of these are very important, is how many children do they have? I mean, if they've already got a bunch of kids, well, do you really want your child getting lost in the mix? Or do they have no kids and you have no example to see how their parenting style is? Additionally, do they plan on having more? Are the children younger or older, about the same age? You know, if the kids are graduating high school and your kid's a toddler, well, maybe it's not the best fit because they've already been through that stage and really aren't ready to start over again. Time and energy, this is a huge one. A lot of times parents are the first choice for raising a kid. Let's take myself, for example. I was raised by my grandparents. I just idolize them and think that they would be wonderful as guardians of my son because they have taught me so many valuable life lessons throughout my life. But they're not good candidates to be my son's guardian because they don't have the time and energy, especially the energy, to take care of a 9-year-old. There's a whole set of needs that kids have that, frankly, older individuals might not be able to keep up with. And then school district, that's another big one to think about, and one that's less often thought about is, do they live in a good school district? Perhaps are they living in the city and would have to send your child to private school, or face sending them to more of a rough public school situation that you would not want your child to be part of? And then another important issue is, we talked about who you would want to be your guardian. Well, another question is, who would you absolutely not want to be your guardian? We can almost all think of at least one, maybe a couple of people, maybe more, in your family and out of your group of friends that, gosh, you could just never imagine them raising any children, much less your children. And so an important thing to do is that with your legal documents, you can make sure that the judge is aware of exactly who you do not want to be your guardian. And sometimes that's just as important, if not more important, than deciding who you do want to be your guardian. All right, so let's summarize where we're at up to this point. Now, we talked about the importance of choosing a guardian and having the proper documentation put in place. We've also talked about some of the factors that you want to consider when choosing a guardian, because it's a very important decision that could have a huge impact on your child's life. And yes, like I said, we've emphasized the need for legal documents. Now, these are not just legal documents that you get online. And so talking about that for a second. Another thing with young people is that, well, they overestimate how much they can do on their own, because we are familiar with the internet and have grown up with the internet. Well, guess what? The internet doesn't care about you. It's not going to develop a personal relationship with you, and it's not going to make sure that your estate planning documents fit your personal needs. There's a lot of people out there that download either free legal documents or templates or something off of LegalZoom that they got for cheap. And the sad thing is, they just don't realize how the words in that document can impact their families and have a real severe negative consequence, and they're just not aware of it. That's the thing about estate planning. You really don't know if it's going to work until it's needed. It's like a fire extinguisher. You know, you just set it in the corner, and when the time comes, that thing better work, right? So it's very important to have quality documents put in place and have a relationship with a law firm, with an estate planning attorney that you know has your back and is familiar with what's going on in your life. So what's next? We're going to talk about estate planning now, moving on a little bit from the guardian topic. And so, like I said in the beginning, this is not your parents' estate planning seminar. This is focused for younger couples. And with younger couples, there's different needs and different solutions. And that's not just true between younger couples and older couples. Estate planning is something that's personal. It's very personal. In fact, that's why we insist upon having free consultations to get things started, because we need to get to know you and your circumstances. You know, do you need estate planning? What kind of estate planning do you need? And also, are you comfortable with us and we comfortable with you? The way that we look at things is that we're not in this to execute a single transaction and get your planning documents set up and then set you on your way and never hear from you again. What we are interested in is developing a relationship with you. Yeah, we want to get your documents put in place, but we also want to be there for you to answer questions in the future, to notify you when there's changes in the law, and to be there when you have changes in your personal circumstance that you can come to us and we can revise your documents. And speaking about revising documents, you know, there's going to be a time in your life where you're going to need to go and look at these documents. In fact, we suggest every 3 to 5 years that you come in for a review. And the reason for that is there's changes in your personal circumstance and there can be changes in the law. And so we want to take a look at your documents and see how they fit. And so there's a joke that, does anybody know the best day or the best time to do your estate planning? It's the day before you die. Why is that? Well, nothing's going to change in the next day. However, of course, that's not a proven idea because nobody knows when they're going to die. And so you need to have these things set up in advance and have a good relationship with an attorney that's going to be there for you to help you change the plan when life changes itself. So some of the different planning options that you have are, first is a will-based planning. So really there's 2 main options. You got will-based planning and trust-based planning. So with will-based planning, to start with, there's what's called a simple will. And your simple will is, its advantages is that it allows you to decide who your guardians are going to be and who is going to administer your estate. And so a simple will is differentiated from a more complex or advanced will in that it just flows the rules with the rules of intestate succession. So it says, to my spouse, and if my spouse does not survive me, then to my children equally. So it's a necessary document, and it's a heck of a lot better than not having any will at all. So much better. For example, a probate in our office, and we'll talk about probate in a second, but a probate in our office typically costs $3,500. If there's no will, you can go ahead and double that price because there's a lot more involved to do a probate that doesn't have a will, that there was no instructions given. The court's going to have to be much more involved. So some of the disadvantages of will-based planning is that it is a one-way ticket to probate court. And what that means is that after you pass away, in fact, there's a lot of confusion about this. Your spouse isn't going to take your will to the bank and expect them to do something with it. It's just not going to work that way. The financial institution is not going to accept the risk of thinking that that's a valid will. What they're going to ask for is what's called letters testamentary. And letters testamentary are what you're given by the judge after you've initiated a probate hearing and the judge has approved you to be the executor. And so even with a will, to be able to take action after your death and able to retitle your assets into the name of, let's say, your spouse or your children, there's going to have to be a judge that approves the whole process. And so a will is going to make sure you get to that point. Additionally, a will only kicks in after your death. It has no effectiveness while you're alive. And so there's no disability planning and preparation put into place with a simple will. So many people think that they're protected by having a will, but honestly, they aren't. Additionally, there's little flexibility, and mainly one of the big issues is that it creates an outright distribution to your children. So let's say your children are of age, they're over 18 years old. What's going to happen when you pass away? Well, all of your assets are going to be divided by the number of children that you have and dumped right in their laps. So there's divide, dump, and what's the last thing? Dissipate. Estates and inheritances do not tend to last long once they've gotten in the hands of children. It's just either they have reckless or more reckless spending habits, or let's just be honest, it's easier to spend somebody else's money or money that was gifted to you. And so that's the way that a simple will would distribute the assets, is it would dump or divide, dump, and dissipate. And one last thing, with a will, as an analogy to think of, a will is like a safety net, like you see under the trapeze artists. It's there to catch you and be there as a safety net for something happens. But again, it doesn't act in disability, and really it doesn't have effectiveness until a judge gives their approval. So we talked a little bit about probate and the letters testamentary that you get from the judge, but what is a probate and what do they do? Well, the purpose of a probate is to, and really the main purpose is to, first of all, appoint guardians of your children, but then also to retitle your assets into the names of your beneficiaries, either your wife or your husband or your children. And so in a probate, what's done is that you apply to the court for a probate hearing, and the court will oversee the whole process in which you resolve disputes, you pay the creditors, make sure everybody's paid off. There has to be a full inventory and appraisal of the assets. That way they can be divided fairly. And then there will be a change of the title on the assets, and the estate will be distributed. Sounds great, right? Well, let's just hope that there's no kinks in that whole process. For example, the first one was resolving disputes. Well, that can just be a huge headache. I mean, there are so many famous stories out there of estates that have gone awry because there was a dispute resolving it or regarding it. And so why avoid a probate? If at all possible, what we always try to do is avoid going to probate court. And the reason for that, first of all, is that it's expensive. It can be. And you've got to pay court fees, publication fees, bond fees, and then you've got to pay who? The attorney to go to court. I'd have to go to probate court and talk to the judge and try to get those letters testamentary. So that all costs money. And it all costs time. It's time consuming. And another one of the big disadvantages of probate and why you want to avoid it is that, like I said, there's going to be an inventory and appraisal of assets done. Well, this probate hearing is a public hearing. And so all of the information obtained during the hearing is going to be public information. That means all of your assets and the value of those assets are now public record. A lot of people do not like that idea. Not just that, whoever is going to be inheriting those assets is going to be public information. So if you're dumping, any amount of money into your children's hands, then there's going to be people out there who are going to look to take advantage of them. And so it's like a red flag to predators out there who may be looking to take advantage of somebody who just came into a large sum of money, or any sum of money for that matter. And then one more kicker, a lot of younger families don't have to worry about this as much, but let's say that you own property in multiple states. Again, most younger couples don't have a vacation home, but let's say maybe you inherited a lease agreement or a royalty interest in another state. Odds are you're going to have to do another probate in that state, because a Texas probate is applicable to Texas assets. And if you got real property in another state, you're going to have to administer the estate in that jurisdiction. And so it's bad enough already having to deal with one, but if you have to deal with multiple probates, it can get expensive and to be a huge headache. So we talked about will-based planning. Our next option, and the one that we really prefer, is trust-based planning. And so you can think of a trust as something of a legal lockbox. And it's really a contract and a legal instrument that you create and agree upon with yourself and your trustees. And so what you do is you title your assets into the name of the trust, and from that point, the trust holds the assets. And you get to decide who has the keys to that lockbox, who are going to be your trustees, who's got the paper or the checkbook. And not only do you have control who controls the checkbook, but you also control what comes out, who it goes to, and when. You know, you might want to wait until they're 35 years old, and then at that point, control the distributions. You also might want to provide incentives. There's a large number of options. I mean, the options are endless. It's really limited by your imagination as to how you want to control this thing. We don't always advise using your imagination too much, because we want to stick to some good standards, but the point is that you'll have a lot more control with a trust. And we also like to analogize a trust to being like toothpaste in a toothpaste tube. So stick with me. With a trust, how I talked about with a will, all of your assets go to your children and they are divided, dumped, and then they dissipate. With a trust, it's like toothpaste in a tube. When your children inherit it, the money is in the trust. It's protected, just like toothpaste is in a toothpaste tube. Well, what do? You each morning, each evening, you squeeze out just as much as you need, right? You don't need more toothpaste, otherwise it's going to get on the counter. What's going to happen is it's going to dry up and you can't use it anymore. Well, the same is true with the trust. You want to keep as much as you can in the trust and just pull out what's needed. And that's going to be the method of operation for your children. And so that they are able to keep more assets protected longer. And then hopefully, really the plan and desire is that ultimately the inheritance that your children will receive will also be received by your by your grandchildren, potentially even your great-grandchildren, because it was set up in a way in which the distributions were controlled and the assets within the trust were protected. And so it can be passed on from generation to generation. So some of the benefits of trust-based planning are, first of all, that it avoids probate. So what I'm talking about here is that with a revocable living trust, that's what I'm talking about when I'm talking about trust-based planning. A revocable living trust is a trust that you set up during your lifetime. You're in full control. You're the trustor, you created it, you're the trustee, you have control of it, and you're the beneficiary. You're the one benefiting from it. So it's basically business as usual, but there's a whole list of instructions for every possible scenario that might come about. You know, there's provisions for what if one of you is disabled, but the other is healthy? What if both are disabled? What if one spouse has passed and the other is disabled? What happens after both spouses pass away? What happens after one of your children pass away? All of that is handled by your trust document. And so with a revocable living trust, the way that you avoid probate is, as I mentioned a second ago, all of your assets are going to be titled in the name of your trust. It's going to be business as usual for you, but your assets will be titled slightly differently. So it's your trust that holds the assets. So if something happens to you, if you pass away, well, you don't have to go to a probate. At least not for as far as your assets are concerned. If you have minor children, you still have to go to probate to establish a permanent guardianship. However, with your assets, there's not going to be any public inventory of assets or anything like that, because what happened? The assets are in the trust. After you passed away, that trust just keeps on going, and we move to the next stage of the process. And so that's how you avoid probate. And it's a great thing because avoiding probate is expensive and time consuming and all the reasons that I just talked about. Some other advantages are that you have greater confidence. You have greater confidence in your plan because it's a more elaborate plan. It's more comprehensive. Also, you just got peace of mind. Now, some of the other advantages are, first of all, this is a big one for couples of any age, but I think it's especially relevant for younger couples, actually. is that it provides protection if the surviving spouse gets remarried. So what I mean by that is, let's say you and your spouse have children and something happened to you and your wife or your husband gets remarried. It's not that terrible thing to think about really when you're younger. For myself, for example, of course I'd want my wife to find happiness. I mean, she's got probably another 50 years, 60 years of life ahead of her. And so sure, I'd want her to find happiness. But in the meantime, I don't want my son to his inheritance to get lost just because everything now goes to my wife. What if she remarried? And what if she remarried but did not survive her new spouse? There's a chance that all of the assets that I left for my son, that I left for Hayden, are now gonna end up going to the kids of somebody who married my wife after I passed away and I never met in my lifetime. That is a scary thought. And so remarriage protection is a huge benefit of having a revocable living trust and a huge benefit of trust-based planning. Additionally, when your children inherit, so after you and your spouse pass away, by setting up a trust, your children are going to inherit into trust as well. And it's an enhanced way of receiving an inheritance. It's enhanced because the assets are not going to be considered to be in their estate. And that's a great thing for your kids, because if they ever got divorced, which, let's face it, in America, there's a high divorce rate. If they ever got divorced, then none of the assets in the trust will ever pick up community property characteristics. Not even the capital gains on separate property held in the trust will pick up community property characteristics. So you can rest assured that what you leave your child as an inheritance is going to stay with your child if they ever get a divorce. Now, of course, you might like, your daughter-in-law or your son-in-law, and I want you to know that this isn't a way of ostracizing them or distancing them. Your son-in-law or daughter-in-law is going to benefit if your son or daughter benefits, right? I mean, let's say they use the funds to buy a house. Well, the spouse is going to live in that house most likely. So everybody benefits from it, but it's a measure of protection that is absolutely important to a lot of clients of ours. It's making sure that if their children got divorced, the divorcing spouse didn't walk away with half of the assets left to their child. Nextly, as I talked about with estate-based or trust-based planning, is that you can really develop a plan to create multi-generational wealth. And so you can create a document that might live to your children or grandchildren or even great-grandchildren if things are managed appropriately. Now, one caveat to that is that these legal documents are specific and thorough, but there is still a need for you just to have conversations with your family about how you look at your wealth and spending and estate planning and really just financial prudence, and also your investment strategies. Everybody in the family should be on the same page. And so that's just based off of personal conversations that you have with your family. One last thing is that with trust-based planning, it's a little bit easier to avoid family fighting just because you've left more specific instructions and there's clearly identifiable people who are in control and who are able to distribute things out and really just avoid conflict. The more certainty that there is, the fewer ambiguities are, the less fighting there's going to be. So let's talk about what a good estate plan looks like for your family. So like I said, and we've already covered some of this, but it's going to provide financial incentives for your heirs. With the trust-based planning, you can provide incentives like they get a distribution when they graduate college, or when they get married, or when they buy their first home. You provide incentives. It's a lot different than just dumping the assets in their lap and wishing for the best. It also helps prevent your heirs from blowing through their money So it prevents them really from hurting themselves. And one place that this is actually really important, I mean, it's all important, but a lot of people that might develop addictions and alcohol problems, other mental issues, if they are dumped a large amount of money into their laps, it can really be detrimental to them. I mean, the whole purpose you're leaving this gift to them is to better their lives. But if they're facing some of these issues, and you can just imagine how an alcoholic or a drug addict would behave if they inherited a large sum of money. It's not going to be a pretty picture. And ultimately, that's going to just be another disappointment on their checklist. And it's a downhill path from there. And so having trust-based planning, you can have provisions in there to hold back the money if some of those scenarios end up playing out. Like I mentioned before, it protects against divorce and keeps the money in the family. That's a big deal for a lot of clients. Provides disability protection before death. So with a trust, just like with death, I said, if somebody becomes disabled, let's say you and your wife are the initial trustees. You're the trustors, you set it up, and you're both the trustees. You're both in control. Well, if something happens to one of you, the other spouse is still in control. That's essentially disability planning. And so it also contemplates for disability planning, which is not true with a will. I mentioned also earlier that it will keep your inheritance safe from creditors and lawsuits. So if your son or your surviving spouse gets sued, we're able to protect the assets, at least up to a certain point, from being accessed by those creditors and judgment lawsuits or lawsuit judgments. But there's really a lot of ways of looking at this thing. So it's important to think about separating your duties, and especially really true with thinking about how your guardianship is handled and how things are going to be handled for your children after you pass away. So for myself, for example, I have a separation of duties in my planning where my guardian of my son is not the same person as who's going to be handling the finances. Because there's a big temptation out there. As much as you may trust who is going to be the guardian of your children, if they're both the guardian and have control of finances, there's temptation. Of course, some people end up spending money on big screen TVs and buying fancy cars that they shouldn't be buying because it's the money that's meant for your child. Of course, that's more of a fraudulent sort of issue, but a much more likely scenario is that what if the guardian has children of their own and they end up, maybe not purposefully, but ultimately end up spending money that was meant for your child on their own children because they just lump everybody in together, and now what's left for your child and what would be there for his or her adulthood is now being spent on the children of the guardian. And so that's a very common situation. And so it's an important thing to think about is that you can divide between who's going to handle the finances for your child, who's going to be the trustee, and then who's going to handle the personal side of things, who's going to be there on a day-to-day, child living in their home, and them, watching over the children on a personal level. And then don't forget that this is all extremely personal. So there are a million different fact patterns out there, but let's look at some of the special or unique needs that are out there. For example, if you're a single parent, well, what if something happened to you? Well, your documents are going to need to address that because there's really not anybody else there to take care of your child. Another one is if you're divorced. You can only imagine when, and this goes back to the separation of roles issue. Let's say you had a divorce, and so something happened to you, and now your ex-spouse is going to become the guardian of your child. Maybe they have visitation rights or something, partial custody right now. Well, they're going to become full custodians and guardians if there's nobody else there and if they're suitable. Well, that means that if you don't have proper planning put in place, the money that you've devised and are giving to your child, you're not going to give it to your ex-spouse, right? Well, you're giving it to your child, but guess what? Your ex-spouse is now in charge of your child. And so your ex-spouse is now in control of all that money. That is not probably what you intended when you left all of your assets to your child. And then lastly, blended families. I mentioned earlier, I was raised by my grandparents. I know all about this from a very personal perspective, is that blended families absolutely need estate planning. The rules of intestate succession, which are basically the state's rules for what happens if you die without a will, who does the money go to, those rules get a lot more complicated with blended families. There's people that get left out that you wouldn't want to get left out. There's people who get lumped in that you might not want to get lumped in. And the whole thing ends up being, a lot of times, a pretty big mess if there aren't proper documents in place. That is the biggest example of where you can see fighting within the family. So now, having gone through all that, what I want to talk about a little bit is about our firm, and then also just tell you really why I do what I do and why we do what we do. So our firm really has five core elements. And of what's important to us and why we do this is that we have a real passion for helping families. I alluded to this a little bit earlier, but I genuinely feel as if this is my calling. And the reason for that is I have personal experience, I have the know-how, and gosh, I just enjoy meeting with families and helping them protect themselves. Additionally, the desire to help isn't any good without a strong, comprehensive knowledge of estate planning and the issues that you might face. And so we do our very best to keep up to date with the latest changes in law and the best strategies to use for estate planning. Next is that we have a dedicated and experienced support team. I probably should have mentioned this earlier, but our team is really what's important. I am so privileged to be able to work with such a great team. So let's take, for example, Mr. Bond, who is the founder of the firm. The firm has been around for 25 years now. And then Stephanie Searcy, our legal assistant and document builder, has been here for 23, maybe 24 years. Again, a very long time. And then Kathy, our other legal assistant, has been here over 15 years. And Mary has been here for a good number of years, 7 or 8 years now. And so I'm actually the newest to the group, and everybody here has just shown nothing but dedication to the purpose of what we do, which is helping families. And that is inspiring to me. It makes me work harder. It makes everybody else work harder because we all have a common goal. And then next is that one reason we do this is that we want to establish ongoing relationships. I talked about this. We're not just in this for a transaction. If you have an estate planning attorney that you've dealt with, or if you go online, of course, if they just try to get you a document, they don't want to learn a whole heck of a lot about you except for, let's say, a couple of questions so that they can fill in their blanks. It's not a good situation. What's important is having a relationship, a trusted relationship. We want to be your advisors. We want to be the people that you call upon when you have a need. And, any question or anything like that, we want to be there for you. I like to say, I want to be your guy. If you need something, you got a guy. Now, if we ever hire, or for any of our female employees, you got a woman also. And then lastly, our fifth principle is that we believe that free consultations are extremely important before we begin any work. And this really goes to the previous point about building relationships, is that if we don't get to know you first, we don't know what your needs are. We don't even know if we're a good fit for each other, because we're in this for a long-term relationship. We want this to be something where everybody's comfortable, everybody's committed, and everybody feels good about what we're doing. And so that's why we do what we do. Now, you may be wondering, we talked, briefly and somewhat generally about will-based planning and trust-based planning. So what we're going to do is make it simple and just divide up in our services into 3 different packages. Now, there can be variations within each one, but we generalized it to 3 different packages. And so your first package is your simple will package. We'll go over each one of these next. Your second is an advanced will package. And then the third is legacy wealth trust package, your legacy wealth trust planning. And so let's talk about each one. So with a simple will package, this is basically your baseline. It is the minimum that we recommend that you have. It's a heck of a lot better than not having any documents at all. I already talked about how a probate without any documents is going to take twice as long and cost twice as much. So it's important to have these documents in place. So what a simple will package is going to do is going to give you your last will and testament, and what that'll allow you to do is select your personal representatives, select your permanent guardians of your children, and also establish a simple distribution plan. So to my wife and then to my children. The package, like I said about wills, a will is only effective upon your death. So if you just have a will, you don't have any disability planning. And 100% honesty, I would much rather, for my family's sake, that I pass away quickly than become disabled for a long period of time, because disability can be a nightmare on the family for many reasons. And so some of the other documents that you receive in a simple will package, it's not just the will, you get your durable power of attorney of property, and that's your financial power of attorney. That's allowing, let's say, your wife and maybe an adult child or a brother or sibling to be able to handle your financial affairs when you're not able to handle them yourself. Additionally, there's healthcare power of attorney. So this is going to be who you select to be able to make course of treatment decisions for you if you're unable to speak and unable to make the decisions yourself. And then you're also going to get a living will. This is also called a directive to physicians. Essentially, this is your pull the plug document. So it's your selection as to if you are either in terminal or irreversible condition, do you or do you not want to receive life-sustaining artificial support? And next, you receive HIPAA authorizations. So that's the authorizations for the people who you select to be your healthcare power of attorney, to be able to receive the information from doctors, to be able to make those decisions, because the HIPAA laws put stiff penalties upon doctors for releasing information when they're not supposed to. So the HIPAA authorization makes sure that your agents are able to get the information that they need. And then lastly, you'll receive an emergency guardianship and medical form. And so this is a form that you'll keep with you and be able to fill out at any time that you know you're going to need. Let's say you're going out of town on vacation, or going on, let's say, a date night, for example. You want to fill out one of these forms. It's quick and easy. And so we'll give you the basic form for that. And that allows you to nominate somebody for a temporary period to serve as your child's guardian and make healthcare decisions for them. Now, the next package that we'll talk about is your advanced will package. So this is going to include everything that we just talked about with a simple will package. However, it's going to add some additional benefits. And so what the additional benefit is that you'll be able to include in it testamentary trusts. So previously we talked about a revocable living trust. So that's a living trust you set up while you're living. There's another type of trust that you can set up, and that's a testamentary trust. So it's a trust that you actually put into your will, and then when you pass away, your estate will still be probated, But after the probate, instead of the kids receiving their assets outright, for example, they'll be able to receive them in a protected manner, similar to what they would receive the assets in a revocable living trust sort of situation. So your children, when they receive those assets and that inheritance, they'll receive in a manner that's protected from divorce, from lawsuit judgments, and also from creditors. This can also be set up for your surviving spouse. If you're worried about your surviving spouse getting remarried, your will can actually set up a trust similar to what we would do in a revocable living trust. Is it would set up a family trust so that assets are available for your surviving spouse during their life. But if they ever get remarried, those assets are going to be meant for your children. And so they're going to stay in the family. And that's very important to a lot of people. And so an advanced will package is a significant improvement upon a simple will package. The one big drawback is that it does still mean you're going to go to probate and go to probate court. And so those fees and that time is still going to be involved. And really the headache to whoever your executor is going to be, whether that be your surviving spouse or whomever, they're still going to have to go through the probate process. Now, your next option and the most comprehensive solution that we offer is the Legacy Wealth Living Trust or Revocable Living Trust planning solution. And so what we're talking about again is a revocable living trust. You control the assets. All of your assets get titled in the name of the trust. And so you avoid a probate. And it also establishes the trusts for your surviving spouse and for your children. And going back one slide, I will say one advantage of the advanced will package that includes testamentary trust within the will is that, yes, you do have to go to probate. And for that reason, for a lot of our older clients, we don't recommend necessarily. We either recommend a trust or a simple will. But an advanced will package does suit well for younger families, more so than older, because, yeah, you'll have to go through probate, but it also means you don't necessarily have to deal with some of the hassles of keeping your trust properly funded. And so when we set up a revocable living trust, we take very seriously the fact that we need to get all of the assets titled in the name of the trust. So the difficult part is up front. We get everything titled appropriately. And then from that point, any new accounts that are created or opened up, let's say you buy a new home. Well, you just have to know that when you open up that new bank account or buy a new home, then you're going to need to buy it in the name of the trust or open it in the name of the trust. Well, some younger couples just don't necessarily want to deal with that for the whole rest of their lives because they have so much life to live and, frankly, a lot of assets and transitions that have to be made. And so with an advanced will package, you have less of that hassle, but you have to deal with a probate. Now, with a revocable living trust, like I said, we go through a lot of that funding stuff up front. I mean, we pride ourselves on it. However, the funding and maintaining it is something that you'll have to keep up with. And so it's just something you have to decide upon, is not going to probate as important to me as having to deal with keeping my trust properly funded for the remainder of my lifetime. And so with this package, you'll get, same as before, you'll get your healthcare power of attorney, your financial power of attorney, your living will, which is that directive or pull the plug document essentially, your HIPAA authorizations, and you'll get what's called a pour over will. So you'll still get wills when you do a trust package. And you might ask, why in the world do I need that? Well, it's because, let's say there was an asset out there, let's say a piece of, maybe a lot, like a lot of land, and it wasn't appropriately titled into the name of the trust when it was purchased. It was maybe purchased under your personal name or your individual name. Well, that means that there's a probate asset out there, because if it's not titled in the name of the trust doesn't control it, and it's going to have to go to probate. So you'll want to have a will, right? And the only thing that will is going to say is it's going to appoint an executor, probably appoint your guardians, your permanent guardians as well, if you have minor children. But importantly, it's going to just say, if there's any probate property out there, put it into my trust. And so it takes that probate property, whatever wasn't in your trust, puts it into the trust, and then the trust controls it from that point on. And that's called a pour over will. And then lastly, you'll get your emergency guardianship in medical form if you have minor children. And so, of course, everybody's want to know, what is this going to cost me, right? Okay, so our protection plan package fees are going to be, for a simple plan, this is just your simple will and the ancillary documents we discussed, is $875 for a single individual and $14.95 for a couple. And then your advanced plan, this is everything in your simple plan plus adding testamentary trusts to improve the way the inheritance is given. Well, that's going to cost $1875 for a single individual and $24.95 for a couple. And lastly, with your revocable legacy wealth trust, that's your revocable living trust, that's going to be a fee that's the same regardless of whether you're single or married. It's going to cost $47.95. So as you can see, there is a lot more cost up front with trust-based planning. There's also a lot more work involved up front with trust-based planning. However, when you start to think about the probate fees that are going to have to be paid later on, well, it starts to become a little more obvious that it's best to go with the most comprehensive plan that you can, because honestly, these things are going to need to be done, all of these actions, either way. The assets are going to have to become retitled at some point or another. It's either going to be right now where you're alive and healthy and competent and you can retitle them yourself into the name of the trust, or you can not have a trust, not retitle the assets, and just know that they'll have to be retitled after your death. The thing is, you're not there after your death. It's somebody else that's going to have to deal with the issues, and they're going to have to deal with a judge to approve all of their decisions and their actions. And so, yes, a legacy wealth trust is more expensive. From our experience and our perspective, it's absolutely worth it, and it pays for itself in the end, provides the most comprehensive protections, but we do understand that not everybody's ready for that at this point in time. So from this point on, we really make the next step easy. And so the next step is that we have a free initial consultation. And again, we really believe that this is the best way of operating, because we need to get to know you and you need to get to know us. And so the way we look at our free consultation is that it's really just a continuation of the discussion that we've had here today thus far. It's just that that discussion is going to be private, and we're going to get far more in depth into your personal situation. And ultimately, the choice is going to be up to you how you want to proceed, but we're trying to make the consultation process as seamless and as easy as possible. And so we know you're busy, we're busy too. And especially with everything going on with the coronavirus, we're actually getting quite good at remote conferencing. And so the options are, you can either meet in our office. When things are operating normally, that's how we prefer to do business, face-to-face. But you also have the option of doing a conference call, or even more preferably, doing a web video call, either using Zoom or Skype or even something like FaceTime, just so we get to see each other, get more of that personal feel. And during the meeting, we've got about an hour to an hour and a half set aside for these consultations typically. And so we like to set an agenda, that way we stay on track and get everything taken care of. And so I think it's important to tell you what to expect, just like you would expect the same from me. And so the first part of the meeting is going to be that I ask you direct questions. Either I or Mr. Bond ask you a series of directed questions because we need to get the information to know more about your family and the needs and the risks that are potentially at hand. Now, the second part of the meeting, once we've gotten those questions answered, is that it'll be your opportunity to ask your questions and really let us know what's on your mind. What has been scaring you? What really have you been worried about? Is there something maybe that you've been misinformed about that you'd like some clarification on? Well, that's going to be your opportunity to do that. And then the third part of the meeting is going to be really a back and forth where we work to develop a plan that works for you personally, based on everything that we've learned up to that point. And we'll also ask, we'll get a feeling by that point. Is there a good fit? Do you like me personally, and do I like you? We want to get along, and it's very important. And then lastly, does it make sense for your family? And so the last thing I'm going to ask is just a simple question. It's a yes or no answer. Is, do you want to proceed forward with us today or not? And again, we're looking for a yes or no answer. And if it's a no, that's perfectly okay. As I've said several times already, this is about relationships. And I'm going to be better off having gotten to know you, and you're going to be better off having attended the conference. However, we do want to know if this is something that we're have the ball on now, or if it's just something left on your to-do list.
I think my husband and I would like to. So how do you want to go about doing that?
Oh, I'm so sorry.
I'm sorry. I said I think my husband and I would like to go ahead and yes, I guess continue with the next step. So how do we go about doing that?
Man, you'd think that I put you there and planned it for you to ask that, because that is actually the next slide.
Awesome. I'm sorry.
No, you're good. It's, sometimes people stage a participant in the crowd.
Oh, goodness gracious. No, I'm not.
Well, perfect. Well, let's get to that. And so step one is going to be, let's bring it all together. So online, you can see the link here, and you should have all gotten this emailed to you also, is that if you go online, Mary's done a great job of adding a lot of functionality to our website. So now you can do your seminar evaluation form online. And simply what that is you put your name, email address, phone number, and then also what's really important is that you let us know what was it in the conversation or the presentation that you're really interested in about. What opportunities are you excited about, and what risks are you scared about? And so that's how you fill out that personal information form. And I can show you at the end. I'll actually go to the web page and show you myself. But so you fill out the evaluation form, and then the next step is on the website, you can request a free consultation. And so there are appointment times listed that you can choose from and set up your own appointment. And so a lot of that functionality is now on our website, and thank you, Mary, for setting that up. Now, and again, I'll go through the website in a minute and show you guys what that all looks like in real live action. But I think it is important to let you guys know that we understand everybody's looking, to get a bargain, especially right now with some of the economic difficulties facing everybody, is that we want to provide a educational certificate for attending this seminar, and you'll get this emailed to you after the seminar, but it's $250 off of all new trusts or 5% off all other planning. And so to be able to redeem your certificate, what we ask is that you set up your appointment online, or you can call our office just as well, and you set up your appointment for the next 4 weeks. And if you're married, then that both of you attend the meeting. I know a lot of times one spouse handles these issues a lot more than the other, but we found that everything runs a lot smoother if both spouses are there. And then lastly, all that we ask is just a simple yes or no upfront upfront answer at the end when we ask if you want to proceed today or not. And you just notice the one thing we didn't include there is a maybe. And so anything besides maybe, you get the $250 certificate. Okay, here's how you schedule the appointment. Is you can schedule online by going to the link provided to you above, and you'll be able to, you can see that you can click on book, and that'll pop you up a whole list of available appointment times. And so you'll click on a day on the calendar that you like, and then you'll be able to click on a time that's available. The other option is the old-fashioned way. You just give our office a call and we'd be glad to get you set up. All right, here's a great quote. I've always loved this quote. So only put off until tomorrow what you're willing to die having left undone. And that was Pablo Picasso, the famous artist that did that quote, but it's really true and really poignant. Is that you got to ask yourself, is this a duty that I'm willing to perhaps die leaving left undone? Or is it the kind of legacy that you want to be remembered for, as having left this kind of fiasco behind for your family? And so I absolutely want to call you to action. This is very important stuff, and there's no reason to delay other than for the purpose of procrastinating. All right, so then one last question before we really wrap this up and get into our Q&A session and go over the website is, was this worthwhile watching today and attending today? I sure hope that it was. Well, I know you guys might be muted, but I certainly hope that it was worth it, and I hope that the information that was presented to you will be helpful. So one thing I want to do before going to the question and answers session is I want to show you what that looks like on the website to be able to make appointments. And so let me escape real quick. Oh, geez.
Hey, Chris, can we help you?
Yeah, please do. I'm having a heck of a time here.
What are we doing?
Oh, I'm just opening the web page to show.
Oh, you have to stop sharing that screen.
Well, I'm on it now.
Oh, okay.
Can you guys see that?
Yeah, we can.
Okay, perfect. So what you'll see is that, first of all, there's a couple of downloads that you can just download onto your own personal device.
We see the presentation, not the web page. You have to stop sharing the presentation. Now share your web screen. There we go.
Okay. Fantastic. Okay, great. So you'll see that under downloads, there's a couple of documents that you can download. Those are great, just reference materials. It'll talk about in more detail some of the issues that we've discussed today. And then down below that is the seminar evaluation form that we talked about, where you can enter your name and personal information. And then also, very importantly, here's the box where you can type in what is most important to you. You know, are you worried about avoiding taxes? Is that your very most important thing? Or are you interested in learning about how protecting your children or your estate from, you know, remarriage of your surviving spouse? Any of those issues, type it in there and it'll be helpful for us. That way, when we get into the room with you or online with you, we already know in advance what's most important to you, and we can talk about those topics. And then you scroll a little bit further, and there is online appointments. And so you click on the button that says book. And there you see there's a calendar with a listing of available dates indicated by the open circle. So let's just say the Wednesday the 22nd. It shows you the available times, either 10 a.m. or 11 p.m. I'm sorry, 1 p.m. And then you can confirm your booking. And so again, thank you, Mary, for all that wonderful functionality. And it's a great way of setting up the appointments, but you can also give our office a call if you're not comfortable with that method. And whenever you do schedule an appointment, we will follow up with you very quickly to let you know that your appointment is confirmed. All right. So what I'm going to do is pull up the presentation one more time. And see if you guys have any questions. Does anybody out there have any questions?
I don't have any questions, Chris, but I appreciate all your information today, and we definitely will be getting in touch with you pretty soon to see about scheduling an appointment.
Well, very good. Well, that's fantastic. And I'm glad that you enjoyed it, and I hope that you got some good information out of it.
Very much so. Thank you very much. I'm going to go ahead and log off. I got a kid that I got to deal with. So
I know what you mean.
You have